Good morning, everyone, and welcome to our Hull and Hull Breakfast series. I'm Susanna Popovic-Montag, and I'm very pleased to be here and to chair our program today. I am joined with our two speakers, David Smith and Paul Trudell, here to my left, and we all welcome you here today. To those who are here in person, those on the webcast, and those who are calling in. One of our speakers was supposed to be Ian Hull this morning, and unfortunately, as sometimes litigation matters go, he just simply cannot be available. And so he sends his regrets and his apologies, and has asked me to step in and present his paper for him. Before we turn to our actual program, I just wanted to start by introducing some of the members of our firm who are here. We have Jonathan Cappy. We've got Moira Visu, Suman Jaffrey, and then two of our law clerks are here, Christine Mercer and Heather Fritchkowski. Natalia, I forgot to introduce you, Natalia Angelini, one of our lawyers, as well as we've got Sarah Koslicki, who is outside assisting us with the signing in. On behalf of the firm, we want to thank you for joining us, as we've got, we hoped, three interesting topics to be spoken about today. Our first speaker is going to be David Smith, and David is speaking on due execution reconsidered.
Good morning, everybody. Paul and I were just actually chatting about titles for papers, and I suppose it's a good question to ask what's being reconsidered. I'm hoping that in due course, as we talk about the topic, I'll be able to get you thinking about some things that I think all solicitors who have an estate planning practice undoubtedly have their own ideas about. I'm going to talk in general about two British cases that kind of guide the profession in terms of what's to be expected in a sort of tricky situation that I'm going to suggest is popping up more frequently than it used to in the past. Before I get started, I just want to thank Moira Vishoyu, my associate. She helped with the cases on this, and Alex Bishop, who's here as well. He's our articling student, or one of our articling students. So thanks to both of them for their assistance. In our practice as estate litigation lawyers, we have various grounds upon which we challenge the validity of a will. And typically the cases that we have are testamentary capacity challenges or undue influence cases or lack of knowledge and approval. Now in practice, we always put in most cases, shouldn't say always, almost always, put in a provision that we're challenging the will on the basis of lack of due execution. Now, more often than not, if it's a lawyer-drawn will, that's not going to be the strongest basis for the challenge. In fact, more often than not, that challenge won't even appear in the will if in advance of the proceeding we've seen a copy of the will, seen the affidavits of execution, seen the records of the lawyer, and have some idea that clearly this was a will done in the ordinary course. The client came to the lawyer's office, gave instructions, lawyer took instructions, drew a will, and then the execution ceremony took place at the lawyer's office. And in those circumstances, we're never going to seriously challenge a will on that basis. Inevitably, sadly, there are clients who will insist that the signature on a will is not that of the testator, even if made in a lawyer's office. We never seriously would entertain that kind of inquiry, obviously, but clients are entitled to their opinions, as we all know. So on the basis that a will challenge predicated on lack of due execution is not going to be one in which the will typically is drawn in the lawyer's office, we then consider other situations. Now, the statutory requirements of due execution, we're all familiar with those. The witnesses present at the same time witnessing the execution of the will and attesting to the signature of the deceased in the presence, or signature of the testator in the presence of the testator. Fairly standard stuff. The exceptions, as we know, are holograph wills and wills made by members of the Canadian Forces in active service. I'm still waiting for one of those cases. I still haven't seen one of those wills, but presumably that happens from time to time. So putting aside the issue of holograph wills and wills made by members of the Canadian Forces in active service, and putting aside the situation where the will is executed in the lawyer's office, now we get to the reconsidering part of what I'm talking about, which is a situation where the client comes to the lawyer's office, says, here's my instructions, please draw my will. Lawyer draws the will, and then the client says, I can't come to your office to execute the will. I live many miles away. Can I do this myself? And so I would expect that in most of the practices of those of you who have estate planning practices, that's going to set off some alarm bells in the sense that immediately we begin to think, well, what is the duty of care in this situation when a client or the circumstances simply dictate that the will may be executed in the absence of the lawyer who drew the will. And I tried to think of some analogies. It's a little bit like golfing. The drafting of the will is a little bit like the driving and the chipping, but when it comes to closing the deal, it's more like putting. You got to be there at the ceremony, and those are the ones that you don't want to be have a case of the yips and miss a short putt. So, the analogy gets a bit unwieldy, but we got to close the deal as lawyers. We got to make sure that this is a valid will, because the easiest case, and I hate to say this, but the easiest case for me as an estate litigator is one where there's a single witness to a will. I mean, it's shooting fish in a barrel for us. That's an easy case, and those are the kind of cases that keep lawyers up at night. And we try in our seminars here not to leave everybody scared to death about walking out the door and drafting wills. But I think in practice, turning our mind towards this issue is a good it's a good exercise to look at what the courts have said. Now, there's two cases out of the UK I referred to in my paper. I didn't include the actual decisions in the productions because they're quite lengthy. I'm happy to send a copy or email a copy to anyone who wants a copy of the cases. So if you'd like them, let us know, or we might be able to post them on our website. The two cases are Esterhuizen and Gray. And they talk about the duty of care, but they say different things. And so I'd like to now briefly refer to my paper, and in particular, on page 4, at the bottom of the page, there's a quote from Esterhuizen. And it says, "A prudent solicitor regards it as his duty to take reasonable steps to assist his client in and about the execution of his will, rather than merely to inform the client how it is to be signed and attested. This means that once the client has approved the draft of a will, a prudent solicitor will either invite the client to his office so that the will can be executed there, or visit him with a member of his staff to execute the will at the client's house." If you look at that for a minute, that's an extremely onerous standard. It's basically saying to the lawyer, look, you either have the person come into your office or you go to their house. I don't care if their house is in Calgary. I mean, clearly that's not a practical solution to the problem. And we'll talk more about that, how this works in practice. Then going on, the judge states on page 5 of my paper, at the top, any testator is entitled to expect reasonable assistance without having to expressly ask for it. It is, in my judgment, not enough just to leave written instructions with the testator. In ordinary circumstances, just to leave written instructions and to do no more will not only be contrary to good practice, but also, in my opinion, negligent. Okay, so it's always good for us, I think, as lawyers to understand where judges can set the bar. The good news for us is there's another case, which is the Gray case. And I'm going to talk about the facts of both those cases in a minute. But what the Gray case says is, well, hold on a second. Look at the circumstances. Look at the nature of the testator. Look at the whole picture. And as litigators, we love evidence. We love looking at the whole picture. saying that every case is determined on its own facts. We don't want any of these cases to end up in litigation. But stepping back and looking at the big picture here, it looks like the one fundamental thing that everybody can agree on, and this is what I want to leave you with, is that a solicitor owes a testator a duty to take proper care in advising the testator of the formalities of execution. So that's the standard of care. The issue is, how do you get there? So now let me talk about the facts in the cases. Ironically, the facts in Esterhuizen, the drafting lawyer, actually did more than the lawyer did in the Gray case, notwithstanding the fact that the judge said it wasn't enough. So let's talk about the two cases. In Gray, I'll do Gray first. Gray talked about a woman who's described, as much of the UK decisions go, the judges are fairly colorful in their language. She's described as lively and vivacious, but then there's something rather sinister. Lively and vivacious with an approach to life that led her on occasions to ignore formalities. So that would be, of grave concern to everybody. The irony is, in this case, notwithstanding the judge saying that that's how she was described, and again, we're talking about the testator, so the judge didn't see her. He just heard what people said about her. So frankly, she sounded like someone who liked a bit of fun and was someone that perhaps the lawyer should exercise a higher duty of care with. Here's what happened in that case. Lady comes to the lawyer's office, says, I'm going on vacation tomorrow. So, okay, it's a law school, bar association course kind of scenario. The lawyer says, fine, takes the instructions, drafts a perfectly good will. She says, I'm going out for dinner tonight with some friends. Can you come to the restaurant and I'll execute the will there? So the lawyer does what she asks him to do, goes to the restaurant. The implication is she's had a couple of drinks maybe, she's having some fun. She says, leave it with me, I'll sign it tomorrow. And he leaves it with her in a sealed envelope with written instructions. The will comes back to him, not before the vacation, but only after the vacation and only after he's made repeated requests for the will. When it comes back, she has signed where the witness should have signed, and the witness and the testator signed where the other witness and the testator shouldn't have signed. But in any event, the lawyer says, well, no big deal. Well, you laugh, but the reality is the judge said it's okay. In this case, he said it's okay. He said that's not a critical problem. The judge in Gray said the lawyer met the standard of care. So this is the good news case for us in the sense that the judge says the lawyer did what he had to do. In that case, leaving written instructions, getting the will back. Now, the interesting part of that case is what I think you all chuckled at, which is when you see an error of any kind in the execution, is that a red flag when you inspect the document that's returned to you that something's amiss? And what the court said is, well, maybe. But let me explain in this case why the court concluded that that was not such an onerous mistake as to put the lawyer on notice that there should have been an error that should have been identifiable. The court said the delay between delivering the will to the testator and the date of execution was not unreasonable. So the judge said, even if you're having to wait for the will to come back to you, that doesn't mean that this was a badly executed will, and it shouldn't twig you to the fact that maybe it was badly executed. The court said the unusual placement of the signatures was not a red flag of undue execution. Kind of interesting. The fact that the witnesses failed to add their occupations beside their names was not a flag that they had not otherwise followed the instructions respecting due execution. And the fact that the witnesses resided in different towns was not a flag that they were not all together with the executor at the time of execution. So I'm pretty sure you're all going to want me to email you the Gray case because it speaks to what's prudent in the circumstances. Now, in contrast, Esterhuizen was a case of an elderly man. Again, totally different fact situation. Elderly, reclusive. The interesting thing about this case is it seems that the will was to a large extent, I hesitate to use the word orchestrated, but clearly one of the beneficiaries had quite a hand in getting the will made. The courts didn't seem to have any concern about that whatsoever. which, as an estate litigator surprised me a little bit, but you take the cases as they come. So the court says, we don't have a problem with the way this will came into being. We've got a problem with the fact that even though the lawyer attended 3 times at the reclusive gentleman's house, he didn't do enough to make sure that he executed the will. And here's what the court said. I think it's a really fine distinction. The testator probably understood that 2 witnesses were needed, but did not have the intellectual equipment or frame of mind to arrange it for himself. So that's the fine distinction between the cases. Different judge, and it turns out that the judge in Esterhuizen was not aware of the decision in Gray, and one wonders to what extent that might have changed his reasoning. But I think it highlights that in every case, you look at the circumstances that present themselves to you, I might respectfully suggest, as a drafting lawyer. And if you've got a reclusive gentleman, here the court, that's the finest distinction you can have, where someone knows 2 witnesses are needed, but can't get 2 people to come to his house because he's so reclusive. And in fact, when the lawyer went to the gentleman's house, he would beg the lawyer to go find a witness to come. And it just wasn't a viable option. But the court said, you know what, it was a viable option. That's what you should have done in that case. Because this guy was such a hermit, effectively, that there was no way he was ever going to get 2 people in his house at the same time so he could execute the will. So I found these interesting cases. When I thought about talking on due execution, my biggest concern was speaking for more than a couple of minutes. But when you get into the subtleties of the decisions, and you look at this particular instance when you're a lawyer attending on executions in these circumstances, and I think they're going to be more increasing in frequency, where you're going to have people who don't necessarily want to come to your office. And so if that's the case, I'm sure you all have good practices in place. If I might respectfully suggest, a very good written template of instructions is good. I think a record of verbally conveying to the client is good. I think very minor points, but important points, like explaining to a testator that you can't have a blind witness, for example, that there's certain things which, and that's one of the things that came out in the cases, certain things that might not occur in the ordinary course. I think you go above and beyond having the client review the written instructions, ensuring they review them. If you have a reclusive client, I think counsel of caution is to go the extra step, as the decision in Esterhuizen suggested. The case in Gray, I think, gives us some comfort that when you get the document back, unless it appears on its face that there was something dramatically wrong, I still question, I think by your reaction I'm judging that you all question whether you shouldn't have seen a red flag when the people signed in the wrong places. But I think fundamentally it's not a scary situation I'm leaving you with. I think it's a situation where I expect you've all got good practices and already implement a lot of them. But it's useful for us to know what the courts say. And again, if any of you want to see the decision, please send us an email, or we could put it on the website, right? Thank you.
Thank you very much, David. As I was listening to you talk about the Esterhuizen decision, I realized that I might have a little bit of a faulty intellectual equipment myself, and that I forgot to introduce 3 of our articling students who are here this morning as well. So I apologize to Noah Weisberg, to Joshua Eisen, and to Alex Bishop for that oversight. I can't blame mine on reclusiveness. It's just probably lack of caffeine. Having said that, I would like to introduce our next speaker, who is Paul Trudell, who's going to speak to us on it and provide us with an update on joint tenancies. Welcome, Paul.
Thank you very much, Susanna, and welcome everyone, and I'm glad you're here today. Today I'm going to be speaking on the topic of joint tenancies, and specifically the severance of joint tenancies and the impact that that can have on the administration of an estate. Take, for example, a case where you have a new client. He's the estate trustee of his father's estate. His father has passed away. He and his sister are the beneficiaries of the estate. In reviewing the assets of the estate, you determine that there's a cottage that's jointly held with another. You look up joint tenancy or refresh your memory on joint tenancy and explain that as a joint property that would fall outside of the estate, and the client may not be happy with that, but that's the advice that you give. I would say that we shouldn't be so fast in giving that advice or direction. Aside from issues of constructive or resulting trusts, the joint tenancy of the property may have been severed, and it's important that we look beyond the mere fact of the joint tenancy. On the other hand, if we take an example of where a client comes in, his elderly father has passed away, and the property that was once jointly held with a prior spouse has been severed by a conveyance from the elderly gentleman to himself, that may sever the joint tenancy. However, there may be, again, not so fast, there may be an issue as to whether that conveyance was a valid conveyance and whether it really does have the effect of severing the joint tenancies. So I'm going to speak of the situations where we need to look very closely at joint tenancy and whether there is or isn't a severance because of the significant impact that that's going to have on the assets of the estate. The joint tenancy, just to go back to the basics, is one of the manners in which property can be owned by two or more people. The other one is tenancy in common. The concept of joint tenancy brings with it the right of survivorship. Under a joint tenancy, upon the death of one of the joint tenants, the title passes to the other joint tenants under the law of jus accrescendi. And I know from my kids' music classes, the crescendo means to get louder or get bigger. Upon the death of one joint tenant, the interests of the other joint tenants gets bigger. Contrast that with a tenancy in common, where the interest of the tenant in common will pass according to his or her will or on an intestacy. For a joint tenancy to exist, there must be the four unities, and to refresh your memory on that, there's unity of title. All joint tenants must get title to the property under the same instrument. Unity of interest, the joint tenants must have identical interests in the property, identical in nature, extent, and duration. There must be unity of possession. The joint tenants must hold the property together, and there must be no separate part of the property that's held by one tenant to the exclusion of the others. And fourthly, there must be unity of time. The interest of each joint tenant must vest at the same time. Failure of any one of those unities will sever the joint tenancy, and a joint tenancy won't be found, and there will be a tenancy in common. Historically, and I'm going way back now to the 1800s, there was a presumption that property that was owned by two or more was owned as joint tenants. That presumption is set aside by legislation, and now the legislation provides that where there's more than one owner of a property, they own the property as tenants in common, unless there's something in the document or how they take title that indicates otherwise. And this applies even if the co-tenants are spouses. Similarly, under the Estates Act, where property vests in beneficiaries of a will, it's deemed to vest as tenants in common unless there's a contrary intention in the will. So we have the basic principles of joint tenancy and tenancy in common. I now turn to the severance of a joint tenancy and what may be considered to result in a severance of a joint tenancy. The classic statement of what will sever a joint tenancy is set out in the 1861 decision of Williams and Hensman. And there it's stated that the joint tenancy can be severed in three ways. The first is a unilateral conveyance of the property. The second is by mutual agreement of all of the joint owners. And the third is by a course of conduct by all of the joint owners that would evidence a mutual intention to treat the joint tenancy as being severed. Dealing with the first principle now, the unilateral conveyance, that's the easiest to identify. Usually you do a search of title and you'll see that there was a conveyance by one of the joint tenants, and you have a severance of there's no longer a unity of title, and therefore the joint tenancy is severed. The clearest example of that is where one joint tenant conveys his or her interest in the property to a third party. If you sell your interest to a third party, there's a severance of the joint tenancy, and the new owners own it as tenants in common. So if A and B own property as joint tenants, B sells their property to C. A and C now own the property, and they own it as tenants in common. The exception to that is where there's a sale to a third party and that sale has not yet been completed. There's a BC decision where an agreement to sell a property will not break one of the unities and therefore it won't sever the joint tenancy. There is a BC case where A and B owned property as joint tenants. B agreed to sell their property to C. Before that sale was completed, however, B passed away. It was found that the joint tenancy wasn't severed and that A got the property by right of survivorship. However, it was subject to C's interest under the agreement of purchase and sale. So the effect may have been the same, but the court found that there was no severance. So a transfer from B, where A and B own property, to C will sever the joint tenancy. That's not the case, though, where that transfer is by will. The will only takes effect on death, and the right of the joint tenant precedes that, and the joint tenant will take the property by right of survivorship before the person takes it under the will. Apart from the transfer from a joint tenant to a third party, the more common way of, a very common way of severing a joint tenancy is a conveyance by a joint tenant to themselves. And that, again, breaks the unity of title. A conveyance by B to themselves would sever the joint tenancy. And for that to be effective, however, the co-tenant who transfers to themselves must have capacity to make the transfer. And if that capacity is challenged and it's found that B didn't have capacity when they conveyed it to themselves, that transfer will be set aside and the joint title, the unity of title will not be severed, and A will get it by right of survivorship. That's normally the case, however. It's not always the case. There's one decision of Bank of Montreal in Bray where a transfer was set aside, and it was found that even though the transfer was set aside, that didn't have the effect, or the transfer did have the effect of severing the joint tenancy. In that case, the husband and wife owned the property as joint tenants. The husband transferred the property to the wife. That transaction was found to be a fraudulent transaction and was set aside. Therefore, the property was put back into the names of the husband and wife. It wasn't an effective transaction as against third parties, the creditor in this case, because it was a fraudulent conveyance. Even though the transaction was set aside, however, as against third parties, it was found that that transaction severed the joint tenancy, and therefore the creditor was only able to execute against half of the property. So the effect of the creditors can have an impact or lead to a severance of a joint tenancy. In that case, the fraudulent conveyance was set aside. In other cases where there are creditors of an estate, the result could be a severance of the joint tenancy. We know that an assignment by one of the joint tenancies into bankruptcy will sever a joint tenancy. Further, actions of creditors enforcing a judgment against one of the joint tenants can result in a severance of a joint tenancy. The 1932 Court of Appeal case of Power and Grace stands for the proposition that where a creditor takes steps to enforce a judgment as against a joint tenant, that will result in a severance of the joint tenancy. It's not enough, however, to file a writ against the property. You must take active steps in order to enforce the judgment, such as advertising for creditors, proceeding through to a seizure. There's one case where the actions of a creditor enforcing the judgment actually worked against their own interests. In the case of Royal and Son Alliance versus Muir, Royal and Son Alliance had a judgment against the husband. The property, the husband and wife owned properties as joint tenants. The creditor took steps to enforce the judgment against the husband. The wife then died. If there was a joint tenancy, the husband would have gotten all of the property and the creditor would have been able to seize the entire property. However, there the court held that because the creditor had taken steps to enforce the judgment, the title to the property was, the joint tenancy was severed, and therefore they can only enforce as against the husband's half of the property. So it can work against you. That's the first method then of severing a joint tenancy, which is by a unilateral conveyance. And that's the only method that doesn't require the agreement or consent or acquiescence of all of the co-owners. The second method is the agreement of the parties. If the parties, even if they don't convey the property, if they come to an agreement that the joint tenancy will be severed, the court will uphold that agreement and find that there is a severance. However, the agreement must specifically relate to the property. Normally in the matrimonial context, we see a separation agreement. The separation agreement can specifically deal with the joint property and severance, and where the parties deal with the property by way of separation agreement, the court will find that may find that there's a specific agreement that the joint tenancy has been severed. And that will be the case even if the agreement is not brought to fruition and there's actually a conveyance or transfer of the property. However, the agreement must be a binding agreement, and I refer in my paper to the Cormier Estate and Bourque decision. There, the parties entered into a separation agreement. The agreement provided that the property that was jointly held was going to be conveyed to the husband. Before that can be done, the husband took his own life. His estate then brought a proceeding to say that he was entitled to the property. The surviving spouse brought a counter-application saying that she owned the property by right of survivorship. And there the court found that the spouse did get the property by way of right of survivorship. There was the agreement that the property would be severed and that would otherwise deal with the property. However, the court found that they had made attempts to reconcile, and the court was able to set aside, in effect, the separation agreement, and the property passed by way of right of survivorship. The third method from the Williams decision is a course of conduct by the parties that would indicate a mutual intention to treat the property as a tenancy in common and not as joint tenants. This is harder to find. There's no conveyance, there's no express agreement that deals with the property, and what the court will look at is all of the circumstances surrounding the dealings between the parties to see if there was that mutual intention to treat the property as a tenancy in common. The intention of one party is not sufficient, and it must be an intention of both of the parties. As stated in the Williams and Hensman decision, an intention declared by one behind the back of the other to treat it as a tenancy in common will not be sufficient. There must be a course of conduct that shows the mutual agreement, not agreement, mutual conduct by the parties that results in the severance. The the course of conduct aspect or test, the third test for severance, was looked at very closely in the recent Court of Appeal decision of Hansen and Hansen. There, the court was faced with a situation where a husband and wife owned property as joint tenants. They separated. The wife commenced a matrimonial proceeding. Both parties retained counsel. There was correspondence back and forth between the parties. It was suggested in one of the letters that the parties would come to a quick settlement. They would divide their property. They would equalize their property. There were a suggestion that the wife would buy out the interest of the husband, and if the husband didn't agree, then the property would be sold and the proceeds would be split. There was correspondence back and forth about how the property would be valued. The wife moved out of the house. The husband took over the bills with respect to the house. Appraisals were done. So there was quite a course of conduct between the parties. The husband then died before anything could be completed. His estate applied for an order that the estate was entitled to one half of the matrimonial property. The applications judge dismissed that application and found that the property passed to the wife by way of right of survivorship. The applications judge found that the second test wasn't satisfied. There was no agreement to sever the joint tenancy, and the applications judge found that the third test, the course of conduct, wasn't sufficient to show that there was a severance of the joint tenancy. The Court of Appeal heard the matter and dealt with the issue of the course of conduct rule in great detail. The court agreed that there was no agreement that reached between the parties that expressly dealt with the severance of the joint tenancy. However, the court found that there was a course of conduct that indicated a mutual intention to deal with the property as a tenancy in common. In making that decision, the court looked at the rule, the third rule, the course of conduct rule, and said that that rule acts in equity. And the court in equity will step in to prevent one party from relying on the right of survivorship, where doing so wouldn't do justice between the parties. So the court may find, depending on the course of conduct, that one party is stopped from relying on the right of survivorship by their conduct. However, the court did say that, unlike estoppel in the usual case, no detrimental reliance is required. They will just look at the fairness between the parties and whether there was that conduct to show the mutual intention. The course of conduct rule doesn't require an express finding that there was an agreement to sever, because that would be the second part of the rule. So something less than an agreement to deal with that property is required. What is required is that the co-owners know of each other's position and that all of the co-owners treat their respective interests as no longer being jointly held. These cases usually arise in the context of a matrimonial breakdown, and even though there is no finalized agreement, the court may find that the negotiation of the shares and interests in the property may reflect an attitude that both parties have agreed that the notion of joint tenancy has been abandoned. So the course of conduct rule requires less than an actual agreement with respect to severing the joint tenancy. However, it does require more than a mere finding that the parties had separated. So something more is required than the mere fact of separation, divorce, or an application for partition. That alone won't result in a finding of course of conduct. Two things should be taken from this, two cautionary tales perhaps. One is that when you're negotiating division of property for spouses, be very careful that your client knows or intends to sever the joint tenancy. Otherwise, it may be that those negotiations unwittingly and without the intent can result in a severance of the joint tenancy. And it should be clear, you should make it clear with your client that that may be the result if you enter into extensive negotiations dealing with the property. Perhaps one way to deal with that would be to have an express agreement that the negotiations don't have that effect, or contrarily they do have that effect. The second lesson to take is that if we're looking at an estate after the fact and there were separated spouses who were negotiating, we can't take the fact of joint tenancy and the fact that there's a joint tenancy on title as being conclusive. We have to look beyond that to determine whether there was a course of conduct that may result in a severance of the joint tenancy. Look beyond the registration to see if there are facts that may support a contrary argument. So those are the three ways that a joint tenancy can be deemed or determined to be severed: the unilateral conveyance, the agreement of the parties, or a course of conduct. Since the Williams decision in the 1800s, there are other manners. One is under the Family Law Act. If spouses reside in a matrimonial property and one of the spouses owns property with a third party as joint tenants, the Family Law Act will deem that severance to be will deem that the joint tenancy will be severed upon one of the death of the co-owner. There's also reference, I'll make reference in my paper, to the fact that if you murder a co-tenant, that may result in a severance of the joint tenancy, which seems fair, I guess. Well, thank you very much, and after Susanna speaks, we'll take any questions that you may have. Thank you.
Thank you very much, Paul. Our last topic now is fiduciary accounts. And we all know that a fiduciary is someone who accepts the responsibility of taking care of the property or the needs of another person, and hopefully will be acting in their best interests. So when we talk about fiduciaries, we are talking about people like estate trustees who are appointed under wills. We're talking about trustees who are named in trust instruments. or guardians of a person or property of an incapable person appointed by order, or guardians of minors' funds. Each of these individuals has an obligation to act in the best interests of the persons over whom they are overseeing the assets, whether it be a beneficiary of a trust or an estate, or a donor of a power of attorney, or an incapable person who's appointed a guardian by virtue of a court order. And together with this obligation to act in best interests is, of course, the duty to account. And that's because we want to make sure that by compelling accountings or offering up accountings that people are acting in the best interests of the individuals. And there is both common law and statutory authority for this proposition of the duty to account. And so when we're looking at what exactly does it mean, we're looking at the relevant statutes, we're looking at the case law that talks about this duty, and also the social and other trends. In terms of statutes, we know that powers of attorney and guardians of property, by virtue of Section 42 of the Substitute Decisions Act, may be ordered to pass their accounts, and or they can also voluntarily choose to pass their accounts. And the language that's set out in the statute itself is quite discretionary and broad. So a court may order it in whatever circumstances it deems appropriate. This authority is then expanded by Section 49 sub 3 of the Estates Act, where a judge on a passing has a very broad inquiry and has a lot of power to make a number of different orders affecting a number of different individuals. The list of the fiduciaries set out in that piece of legislation include an executor, include a trustee, and an administrator. And when you're dealing with these kinds of orders, we see that judges can make, surcharge or falsification orders on passings of accounts. They can make orders for costs, either against a fiduciary or in favor of the estate or the trust. And they can even order damages. And so the remedies are quite broad. And then procedurally, of course, we have Rule 74.15 of the Rules of Civil Procedure that provides that anyone with a financial interest in an estate can apply to compel an estate trustee or an attorney to account. So that's sort of the legislation that gives the authority for people to compel or to voluntarily pass accounts. We then turn to the cases to sort of see, well, how is it that these pieces of legislation are being put into place and what kind of obligations are being imposed on fiduciaries? And really the starting point is always the Reed-Tarrick decision, which is a 1975 decision of the Ontario Court of Appeal, where the court confirmed that a judge does have a very broad right of inquiry, and a judge can compel both an estate trustee and an attorney to account. The Rees-Silver decision, a 1999 decision, then talks about whether or not you need probate to compel an estate trustee to pass accounts, or whether or not you need probate to voluntarily pass your accounts. And that decision stands for the proposition that you do not need to have probate in order to either voluntarily or be compelled to pass accounts. And that's because it's within the court's inherent jurisdiction to supervise fiduciaries, and they can have an accounting being ordered. The Roger Estate and Leung talks about the fact that an attorney is a fiduciary. And it also sets out, once again, and refreshes basically the law and the rules that apply, and the fact that an attorney has to be ready to provide an accounting upon request. They have to keep their affairs separate from the funds that they are overseeing as a fiduciary. They've got to keep vouchers, and probably for a pretty long time. They've got to prepare their accounts in court format if they're asked to do so. And we've got a format that specifically has to be applied, and they are required to follow that. They are required to make beneficiaries aware of their rights, and also to advise them if there's been a breach of a trust. Not necessarily the easiest conversation to have with beneficiaries, but certainly part of their responsibility. And the reality is that this is an ongoing obligation. And so it continues and is something that you've got to be aware of as a fiduciary. The Fair and Campbell decision was a decision in 2002 that talks about the fact that an attorney is a fiduciary, but there are different duties that would be imposed upon that fiduciary depending on whether or not the donor is capable. And so in that case, we had the authority being provided by the court that a capable donor in a situation where someone is seeking a passing of accounts would not necessarily be able to insist upon it. So then we've got the Cornacchia decision, which is an interesting one in the sense that it provides us with authority for the fact that you don't need to be the personal representative of a deceased in order to compel someone to pass accounts. In that case, the court looked at Section 42 of the Substitute Decisions Act and looked at the list of people who could compel a passing of accounts. And that included a grantor of a power of attorney. That included a guardian for property or for personal care, and that whole catch-all phrase of any other person that the court would allow with leave to compel a passing. And the fact that the individual looking to compel an attorney to pass accounts would have an interest in the estate or in the result didn't matter. It was something that the court could exercise its discretion on and make that order compelling an accounting. And then we've got the high watermark case. I always enjoy talking about the Farid and Wood decision, which is a 2005 case that really, I think, is one that makes predicting whether or not an accounting is required and when it has to be, from what time frame it's got to be imposed, the most difficult to predict. In this case, the solicitor was named the power of attorney for an individual. He also drafted the will for that individual and was appointed the estate trustee under that document. And all I can say is I don't think the court really liked this lawyer. And the reason for that is because in this case, the court held that the attorney had an obligation to provide an accounting right back to the date of the actual execution of the power of attorney. So this is notwithstanding the fact that the attorney didn't actually act because the individual was capable for a certain period of time and would have argued that they should only have to account from the point in time where they actually took steps on behalf of an incapable person to become their attorney. But the court said, no, you have to account right back from the date that the power of attorney was actually signed. And the fact that the grantor herself at that time was doing stuff and was fully cognitive didn't matter. You still had that obligation. So kind of a scary decision, but it is out there and it hasn't been overturned. So when we talk about, obligations, it may be that we actually have to account right back to that date. It'll be very difficult, no doubt, but certainly something that we've got to be prepared for. The McAllister decision was another interesting case, which set out really the test of when you're going to have to account. And this one sort of was dealing with the fact that the grantor of the power of attorney was alleged not to have been incapable. And so the argument was, therefore, I don't have to account. The court basically imposed a two-part test to provide us with some guidance as to when you would have to account. The first part being, what was the extent of the attorney's involvement in the actual management of the grantor's finances while they were alive? And has the application that the court is dealing with raised sufficient concern that the grantor's affairs do warrant an accounting? And in that case, even though it was resisted, the court ordered the attorney to provide an accounting. And then lastly, of course, we've got the executor de son tour kind of scenario where someone isn't actually appointed by virtue of any document, but takes steps by which it may be argued that they have assumed the role of a fiduciary and therefore assumed the obligation to account. It's sort of that old adage, if it looks like a duck and walks like a duck, it is a duck, and you're going to have to account for the fact that it was a duck. So we want to be careful of those kinds of situations and whether or not, what kinds of steps will amount to sufficient steps to impose that duty. So knowing then these kinds of obligations that we have to account, how do we actually do it? The first question, I think, always is in what jurisdiction, if you're going to compel someone to pass their accounts or if you're going to voluntarily choose to pass your accounts, where do you do it? And there used to be a school of thought that said, well, if it's an executor, you'd be seeking to compel them or have them voluntarily pass their accounts in the jurisdiction where that issued the certificate of appointment. And if it was an attorney or a guardian, then in the jurisdiction making the order, that court where that order emanated from. As a result of the Reed-Pearsall decision of 2009, Justice Brown has given us a very practical answer to that question and has told us basically that as practitioners we can choose the most convenient jurisdiction to issue those applications, and that's in accordance with his usual train of thought of being very practical and cost efficient. So that's good guidance to us as practitioners. Passing of accounts, what does it actually entail? Well, there is guidance that's provided to us in the rules that talks about the fact that you've got to have an actual set of accounts in proper court format. You've got to have the fiduciary prepare an affidavit that verifies the estate accounts. You'll have included in that a certificate of appointment if one is obtained, a copy of the last order passing the accounts if the accounts were previously passed, a notice of application to pass accounts, and we want to make sure that we're serving that on everyone with an interest of contingent or a vested interest in an estate or in the trust fund. And we never want to forget the possibility that the children's lawyer and the public guardian and trustee has to be served as well. And then as a part of that pretty package, of course, we include the filing fee and we send it off to court. And hopefully all of this has worked well and our accounts are passed on consent. Not necessarily the reality for us at Hull & Hull, because many times what we get in response to that is a notice of objection. And that is a specific format that is set out by the rules, and the form is a form under the Rules of Civil Procedure that tells us how it is that we object to accounts. And we see typically the biggest objections being based on compensation and on specific entries in the accounts and how the attorney has actually conducted themselves. So when we talk about hot button issues, as I said, compensation tends to be the most litigated one that we see. And the reason for that, I think, is because we're seeing larger and larger estates these days, and as a result, we're seeing the quantum of compensation going up. And many times we know that no good deed goes unpunished, and no one likes to pay someone to do something that they don't realize the value of. The other thing is that compensation is very discretionary to a judge as well, and so it leaves a lot of leeway in terms of what the proper compensation amount should be. There's both statutory and common law authority, again, for compensation. We've got the Trustee Act, and Section 61 of that talks about compensation that is it can be claimed by estate trustees and trustees, and it's based on such fair and reasonable allowance for the care, pains, trouble, and time expended in or about the estate. So again, very broad language in terms of what are care and pains and how much time was expended. So it gives a lot of leeway to the courts. When we're talking about attorneys and guardians and seeking compensation, there's a little bit more of a regime in the sense that there are regulations under the Substitute Decisions Act that specifically provide for how much they are entitled to for compensation. And we know that it's 3% of all of the capital receipts that come into the estate and capital disbursements that go out. Similarly with the income receipts and income disbursements, 3% of that. And then a care management fee of 3/5 of 1%. So depending on the nature of the fiduciary, whether it's a trustee or an estate trustee or whether it's an attorney or a guardian, we're going to be trying to figure out how are we going to seek and determine compensation. And what we've developed as a practice really is a means by which we take the 5 factors. It's a 5-factor approach that's set out in the case law, very discretionary, based on things like the size of the trust, things like the care and responsibility involved in administering the trust, how much time was expended, what was the skill and the ability shown by the fiduciary, and what was the ultimate success resulting from the administration. We take those kinds of factors which reflect, according to the cases, the care, the pains, and the trouble, and the time expended that the statute talks about, and then we temper that against the clinical, the mathematical, entitlement based on percentages. And for trustees and estate trustees, we've got this rule of thumb, this tariff amount. It's not really formalized, but it's certainly accepted, being about 2.5% of the value of the assets coming into the estate, and again, the value of the assets being paid out. And that, together with a care and management fee, is what people are looking at for compensation. And when we're looking at accounts, we know that we start with, when we're acting for a fiduciary, preparing accounts, aiming high and providing for a claim for compensation that we feel comfortable with as practitioners recommending, knowing that at the end of the day, once the beneficiaries and the people have looked at the accounts, that might be reduced. If we are aiming high, we might consider including a special fee in situations where it might be something that the fiduciary is entitled to. You'd look for a special fee in a situation where you've got an estate that's gone through litigation, for instance, and the trustee's been conducting it or defending it, been involved in it. They might say, you know what, I'm entitled to more than I would be otherwise, just based on the percentages or the discretionary component of a judge's decision. Or if an estate trustee is operating a business for a period of time after the deceased's death and has done well for the estate, in that case they may be looking for a special fee. Most of the times, though, what we see are people trying to reduce the claim for compensation, and the argument being that, you know, the complexity of the estate when you're dealing with in-specie transfers is not that hard. If there are huge amounts, and we're talking about amounts in bank accounts or in investments, and there's not a lot of management that's being done with them, people again will look to reduce the percentages that are applied to those kinds of ins and outs into an estate accounting. When you've got the use of trust companies, or you use accountants to prepare tax returns, or even to prepare the accounts, or you use lawyers to act and fulfill some of the estate trustees' duties, those are also flashpoints for people to seek a reduction in the accounting. And we want to be careful as we're counseling our clients as to whether or not that makes a lot of sense, either in making that pitch or in defending it. One of the things that we always watch out for, too, is the pre-taking of compensation, something that, according to the Re-Knox decision, we know is an absolute no-no, unless, of course, the trust instrument or the will allows for that kind of pre-taking to be done. Otherwise, really, we are looking at the mercy of the beneficiaries. They're consenting to you pre-taking compensation, if that's what they're prepared to do, or ultimately a court order on a passing of accounts allowing that to happen. We want to be very careful that even if we are pre-taking, that we're not overreaching, so that we don't have a situation at the end of the day when we have to be paying back money, and with interest to boot. So just some of the things that we keep in mind when we're reviewing accounts and preparing them for fiduciaries. There are, of course, a number of ethical obligations that arise for us as solicitors when we're dealing with these situations, I think, as well. And Paul had mentioned the joint accounts, the joint tenancy kind of situation. And based on the Pecori decision, I think now we tend to do a little bit more probing with our clients when we're deciding whether or not joint accounts should or should not be included in estate assets. And also dealing with issues of the entitlement to a release on a passing of accounts. We know, of course, we can't hold estate assets hostage until we get a release, but these are important conversations that we have with our client as to whether or not we should be recommending that the release request come with an independent legal advice suggestion, that we want people to have independent legal advice before they sign releases and in order to get their funds. In terms of, I think, one of the most trickiest situations when we're talking about ethical obligations and dealing with solicitors is the solicitor who's acting as an executor, when they're actually looking to charge legal fees for their work as lawyers and sort of comparing that to their entitlement to compensation as executors. And there's a little, certainly a fine line between that, and we want to make sure that we're on the right side of that at the end of the day. So as I'm just looking towards wrapping this up, I think there are these kinds of situations when we're dealing with fiduciary accounts are ripe for a lot of conversations to be had with our clients. When we are preparing accounts, when we're acting for fiduciaries, we certainly want to recommend that they're as transparent as possible and that they really do communicate with the beneficiaries of the trusts or whoever is involved. The last thing you want to do is to have someone come across as a very arrogant executor, someone who's going to just run this estate, because all it does is it creates a distrust. And the last thing we want at the end of the day is litigation, especially in this area of the law, which tends to be very, very contentious, extremely time-consuming and expensive, and I'd say almost never rewarding. So thank you very much. So we'd now like to move into the question and answers portion of our program. If anyone has any questions, we ask you to please come up to the mic to pose them to us, and we'll do our very best to respond.
If you wanted to bring, Paul, if you wanted to bring an application to set aside a conveyance, severing a joint tenancy and claiming damages, would that be brought into state's court or under an ordinary action?
I guess, is this in the context of an estate administration? Are you seeking to...
Well, there was a conveyance done, severing joint tenancy. Subsequently, there was a death of the person who severed the joint tenancy by doing a conveyance to herself originally. So
I recently did one, and it was in estates court. However, it was coupled with a dependent support claim in the event we were not able to set aside the transaction. So I don't know if it was just, if the issue was just the setting aside the conveyance, whether that would be one that would be properly brought in the estates court.
So do you think it should be brought in the ordinary courts?
I
You're
think
claiming
so.
damages as well.
I would check the practice direction as to what matters can be brought in the estates court. I'm not sure if it would necessarily fall within the estate court's jurisdiction.
The other question is, if there's 3 joint tenants, husband, wife, and daughter, the matrimonial home, husband dies, do the 2 remain, the wife and the daughter, do they remain as joint tenants, or is it severed?
They would remain as joint tenants because their interest, their unity of title is still from that original title that gives them property.
So, because you mentioned earlier that that there would be would turn into a tenancy in common if it was a matrimonial home?
If it's owned with another, so if the 3 of them owned it as another, that might, result in a
No,
severance.
they owned it themselves, the 3.
It was the husband and wife
And
the
daughter.
daughter. Because the daughter is involved, then
Yep.
that way sever the joint tenancy under the Family Law Act. And they would then take it as tenants in common.
The remaining 2.
Yeah.
Thank you.
I have a rather peculiar form of joint tenancy. Very briefly, brother and sister are involved in a corporate interest. Brother inherits half of the shares of the company from his mother's will, who passed away, let's say, 5 years ago. Father survives the mother, and he and the sister enter into an agreement to issue shares jointly. Now, when the father passes away, can the sister exercise a right of survivorship, or is a corporate joint tenancy not really valid or used?
So the joint property here are the shares that
Are the shares. Clearly, the brother has a half interest because he got them from the mother.
Right.
The father and the brother ran the company. Now the father has passed away, and the sister comes to us and says, well, these shares were issued jointly between my father and myself, so they should come to me as a survivor. They don't need to be probated. It's a kind of poor man's version of doing a double will. Would that fly?
There probably is an agreement that could be, if they did own the shares as joint property, then and there was an
So
agreement
shares
that-
can be jointly held then?
I believe they can.
Oh, I see. So it would depend on the kind of tests that you provided.
Yes,
Intent.
The test that I was setting out deal with real property.
Yeah.
But there could be an agreement like a bank account. You could agree that it's held with the right of survivorship,
Yeah.
and the shares could be held in the
Yeah,
same.
though bank accounts have been notoriously tricky,
Yeah.
whether there really is a genuine joint tenancy or whether it's a kind of agency factor that works there. So I was
And with
wondering.
bank accounts, the courts are very likely to find a resulting trust.
Quite. Okay, thank you.
Just a quick question. I saw a will the other day, and it said that the executor had no obligation to pass accounts. I'm just thinking that's probably not binding, but I was wondering what your opinion is on that.
That's a great one. So the executor is not required to pass accounts? And that's in the will itself?
The will says, yeah.
Is the executor the lawyer who drafted the will?
I don't know.
I think that would be an easy answer. I mean, I think ultimately it's certainly persuasive. I think a judge will be persuaded if there is no conflict in that it isn't the executor, for instance, because the testamentary document is the one that's going to govern it. But it may be if there's any concern about public policy considerations or if there's been any kind of an indication of some kind of malfeasance, misfeasance, pretty bad behavior. I think that even that might be difficult to overcome, but it would really depend on, you know, what it is that's being alleged and in what circumstances and who prepared the document.
Okay, thank you.
You're welcome. Did you have any comments? So do we have any other questions at all? no, then we can all rush off back to our offices in time for the day. Thank you all very much once again for attending.